If you were born before 1960 and somewhere along the line you lost your right to own or carry a firearm, whether from an old conviction, a past mental health record, or a legal situation that happened decades ago, then what is quietly happening in federal courts right now may be the most important thing you hear all year, because a constitutional shift that most people have never heard of is already giving some Americans their Second Amendment rights back. And if you are 65 or older, there is a real chance this applies directly to you. Let me be honest with you before we go any further. This is not a political video. It is not about taking sides on gun control, and it is not here to tell you what you should believe. What it is here to do is inform you of a genuine legal development that your attorney probably has not called you about, that your congressman has not sent you a letter about, and that the evening news spent about 45 seconds on before moving to the next story. You deserve to understand what is actually happening in plain language, so let us get into it. For most of the last 50 years, the standard used by courts to decide whether a gun law was constitutional was a balancing test. Judges would weigh the government's interest in public safety against an individual's right to bear arms, and in most cases, the government won. People who had been convicted of a felony, even a nonviolent one from 30 or 40 years ago, were permanently barred under federal law from possessing a firearm. For many Americans, that meant a mistake made in their 20s or 30s defined them for the rest of their lives. No path back, no review, just a permanent prohibition that sat on the books long after they had paid their debt to society, rebuilt their lives, and become productive, law-abiding members of their communities. That framework cracked open in 2022 when the United States Supreme Court issued its decision in New York State Rifle and Pistol Association versus Bruen. The court ruled 6-3 that the Second Amendment is not subject to a government interest balancing test. Instead, any law restricting the right to keep and bear arms must be grounded in the historical tradition of firearm regulation in America at the time the Constitution was ratified. What that means in practical terms is this: if a restriction on gun rights did not exist or have a close equivalent back in the late 1700s, it has a very difficult time surviving a legal challenge today. That single ruling opened the door to a wave of constitutional challenges that are still working their way through the federal court system right now. And older Americans, people who lost their rights under laws that were passed or interpreted decades after the founding era, are at the very center of those challenges. Here is where it gets specific and where you need to pay close attention. Federal law, specifically 18 U.S. Code, Section 922, prohibits anyone who has been convicted of a crime punishable by imprisonment for more than 1 year from possessing a firearm or ammunition. That category covers a very large number of nonviolent offenses that were treated as felonies in the 1970s, 80s, and 90s. Things like passing bad checks above a certain dollar amount, low-level drug possession with intent charges, certain fraud offenses, old tax violations, and a range of other offenses that today would either be charged as misdemeanors or would carry significantly lighter penalties. Millions of Americans are caught in this prohibition, and a significant portion of them are seniors. Since the Bruen decision, multiple federal circuit courts have issued rulings saying that applying this lifetime prohibition to nonviolent offenders is unconstitutional as applied to certain individuals. The Eighth Circuit, the Third Circuit, and several district courts have found that there is no long-standing historical tradition in America of permanently disarming people who committed nonviolent crimes. The founding era dealt with violent criminals very differently than it dealt with nonviolent ones, and that distinction matters enormously under the new legal test. These are real rulings, with real people having their rights restored, and the trend is accelerating. Now, what does this mean for you if you are over 65 and you have a disqualifying record from the past. It means you may have legal standing to challenge your firearms prohibition in federal court as an unconstitutional as-applied violation of your Second Amendment rights. This is not automatic. It is not a blanket amnesty. You cannot simply decide that the law no longer applies to you and walk into a gun store. That would be a federal crime. But what you can do is consult with a Second Amendment attorney, and there are more of them now than ever before, about whether a petition or a legal challenge in your district could restore your rights. The answer in many cases is yes. There is also a second avenue that has existed for a long time but is rarely used because most people do not know it exists. The Federal Gun Control Act includes a provision allowing individuals to petition the Bureau of Alcohol, Tobacco, Firearms, and Explosives for a restoration of firearms rights. Congress has defunded that program at the federal level for decades, meaning ATF cannot process those applications. But here is the part most people miss. If you obtain a restoration of civil rights under state law, whether through a governor's pardon, a certificate of relief, an expungement, or a formal rights restoration process, federal law recognizes that restoration in many circumstances. 31 states currently have some form of automatic or petition-based rights restoration process. If you live in one of those states and you have a qualifying conviction that is old, non-violent, and has not been followed by any additional criminal history, you may already be on the path to eligibility and simply not know it. For seniors specifically, there is another layer to this that does not get discussed enough. Some people born before 1960 lost their gun rights not through a criminal conviction, but through an involuntary mental health commitment or adjudication that happened decades ago. In some cases, these were short-term hospitalizations from the 1960s or 70s, back when the standards for involuntary commitment were far broader and in many cases were applied in ways that would not pass legal or ethical scrutiny today. The legal landscape around mental health-based firearms prohibitions has also shifted post-Bruen, and several courts have looked carefully at whether decades-old mental health adjudications can constitutionally sustain a lifetime gun ban. If this applies to you, a legal consultation is absolutely worth pursuing. Veterans also deserve a special mention here. Certain veterans received less than honorable discharges for conduct that at the time was treated as a punishable offense, but that would be handled very differently today. Particularly those involving mental health crises, PTSD before PTSD was even officially recognized, and administrative decisions made in the 1960s and 1970s. The Department of Defense and several courts have opened pathways for discharge upgrades that can, in turn, affect firearms eligibility. If you served, received a less than fully honorable discharge, and lost your gun rights as a result, that situation may be worth a second look. Here is what you should do if any of this resonates with you. Start by getting the exact record of your disqualifying event. Contact the county clerk or state repository where the conviction or adjudication occurred and request your official criminal history record. Then look up whether your state has a rights restoration program and what the eligibility criteria are. The National Rifle Association's Institute for Legislative Action maintains a state-by-state guide, as does the Giffords Law Center, so you have access to solid reference material regardless of your politics. From there, find a firearms attorney licensed in your state. Many offer free consultations, and the conversation will tell you within 30 minutes whether you have a viable path forward. Do not assume the answer is no just because it was no 10 years ago. The legal ground has shifted under your feet in a significant way. Courts that would have dismissed these claims before 2022 are now taking them seriously. Attorneys who would have told you there was nothing to be done are now filing petitions and winning. People in their 60s, 70s, and 80s are having rights restored that they thought were gone forever. That is not a promise that you will succeed, but it is a reason not to give up without asking the question. The Second Amendment was written for everyone, including people who made mistakes they later paid for, people who served their country, and people who simply want the ability to protect themselves and their families in the later chapters of a long life. If your rights were taken away under a legal standard that courts are now rejecting, then you deserve to know that. Share this with someone you know who needs to hear it. And if this is the kind of content that helps you navigate the systems that affect your life, consider subscribing because there is a lot more coming that you will not want to miss.